All those kind of business for the court draw near. The Honorable Judge J. Cedric Simpson presides.
You may be seated. You don't have to sit down, but you may. You know, we go find her. You're gonna go find Tana? Because I got Hawthorne here. He don't know what he's doing. Lowe doesn't know the court rule.
I'm ready to go, Your Honor.
Yeah, I know. It's all set over here. That side looks a little bit discombobulated. I don't know.
Trying her best.
Well, Her Highness has arrived. All right.
Oh.
What'd you say?
Oh, the waiver. He's...
Yes, I was waiting for the waiver, and I
did not know.
We need some more training.
No, he heard it on both sides. I don't even, how do you not know it, Hawthorne?
Let's see how I do with it, and then
Okay.
about not knowing it.
All right. Go ahead, Ms. Tanner.
Your Honor, at this time, the people of the state of Michigan move to waive any potential conflict between Your Honor, Honorable Court, and the Public Defender's Office. We do not believe a waiver exists. However,
A conflict exists, you mean?
a conflict exists.
Okay, go ahead. I'm sorry.
A waiver does exist, a conflict, no. But if one were to arise, Your Honor, we would waive it.
All right, very good. Ms. Pate, you know it, right?
I don't know, I screw it up all the time that I'm here.
You do, but go ahead.
I get through it though. Your Honor, Assistant Public Defender Natalie Pate, they have the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between our office and this honorable court, but if one were to wherefore arise, we would waive such a conflict.
Thank you both. The court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Nicholas Pasanic.
Good afternoon, I'm Marie Tanhouse, the prosecuting attorney on behalf of the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Bosnack, who should be present via Zoom.
Well, I have two folks.
Sam's not Mr. Boston.
No.
He is on you.
Bosnick? Is that how?
Yes, I'm here.
Yeah. Okay, I need a camera, please, sir.
It should be on. Yeah.
It may be covered.
It's off.
It's off now. There it is.
How about now?
Yep, there it is. All the way from New Zealand.
Yes, Your Honor.
I see, I remember. I
Yes.
absolutely remember. Because I mispronounced his name and he's in New Zealand. That's how
Yeah, he is here. And I have discussed this matter both with my client as well as with Ms. Zenda. And we were hoping, me and my client, to set this case for final settlement conference. I do not anticipate it moving forward to jury selection. I did speak with Ms. Zenda regarding her thoughts on that. And if the court were to somehow agree, if you would allow him to appear via Zoom for an August final settlement conference. I have discussed that with my client, and that is what he wishes to do. I do understand that the court typically has, of course, final settlement conferences in person.
Yes.
And I will just add for the record, if this does play a role, this is a 2003 case. And of course, as Your Honor is aware, he does reside in New Zealand.
Well, really what I should do is make him come here and then take us back with him to New Zealand. That's really what I should do. But I'll...
For the record, the people would leave it to the court's discretion.
All right, thank you. What I will do then is I will set jury final settlement conference for
August 8th, 2025 at 9 a.m.
is it the 8th or the 7th? Okay, it is the 8th. August 8th, 2025, 9 a.m. Jury selection would be, if necessary, August 11th, 2025 at 8:30. What I'm going to do is I will mark the file in person, but then note that defendant I will permit to appear via Zoom under state circumstances. If for whatever reason, so that the parties would know, if for whatever reason it would need to go to trial, I would be setting the next dates, which would then be in October. Those would be in person, but the defendant's attendance would be mandatory at that point.
Absolutely, Your Honor.
Okay,
Thank you.
all right. Thank you.
Yeah.
Thank you, sir.
Thank you. And what are those dates for there?
August 8th,
Yep.
2025. That's at 9 a.m. That's the jury final settlement conference.
Yep.
I pair that up with the jury selection, understanding that it would not go because I'm allowing you to appear via Zoom at this point. Jury selection would be August 11th at 8:30.
The 11th at
Yes.
8:30.
Yes, sir. So you had the 8th and the 11th.
And the 11th at 8:30.
Yes, sir.
And that's AM US time.
Yes. Yes. Because I have no idea what time it is in New Zealand.
It's 5 a.m. right now.
Is it? Okay, 5 a.m. Are you still on our date? Because we're the what?
No,
30th?
I'm a day ahead. I'm a day ahead. I'm on the 1st.
Yeah, that's what I thought. Okay.
Yep.
All righty, sir. You take care of yourself.
Great. Thank you so much. See you then.
Thank you, sir.
Court does call the case of the people versus Eric Buckner.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the people. And Assistant Public Defender Natalie Pate on behalf of Mr. Buckner. Your Honor, I have spoken with Mr. Buckner several times in anticipation of this court date, and he was aware that he was to appear in person. My latest update from him was that he texted me at 1:01 stating that he, split up, Your Honor, I apologize, that he is in the hospital. I asked for proof of his admission and he responded that he was talking to a nurse and he would send some, but I still have not received any. That is my explanation for his failure to appear. I do understand the situation, but for the record, would respectfully request an adjournment of this hearing.
In your response to the people.
Your Honor, I think the court knows more about the background of this case than I do, but my understanding is he is supposed to be here in person.
Yes.
I also have grave concerns about the safety of the victim. I have reason to believe that he has been stalking her, which would be no surprise given the background of this case. Given those concerns, Your Honor, I would ask for a warrant with a high surety bond.
What I will do in this case is I'll issue a bench warrant for the defendant's failure to appear. I'll set bond in this case in the amount of $15,000. Cash surety is paid. If there is information that comes through, then the court won't have a problem necessarily setting it aside.
Absolutely, Your Honor.
All right. That warrant will issue immediately. Thank you. Court does call the case, People versus Douglas Lee. Uh-oh. Uh-oh. Hold on. Slow down. Just slow down. Let's get it right.
Requesting permission to practice pursuant to Michigan Court Rule 8.120. Under the supervision of Assistant Prosecuting Attorney Maria Tan.
Permission to practice is great.
Hello for the pupils.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Douglas Lee.
All right. Thank you, sir.
Thank you, Your Honor. I have discussed this matter with my client, and at this time, he wishes to set the case for final settlement conference.
Jury final settlement conference, August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person.
Yes, sir.
All right. Okay, thank you.
Thank you, Your Honor. Thank you, Mr. Lee.
Excuse me. What date was that? Is that August 8th?
Yes.
August 8th for jury final settlement conference, and then the August 11th would be jury selection if it's needed.
Yes, sir. Yes, sir. Thank you.
Thank you. Bond continued.
Thank you.
Court calls the case of the people versus Jaquil Lloyd.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lloyd, who is present via Zoom. Sir, excuse me, can you please state your name for the court?
Yes, Jaquil Lloyd.
Thank you, Your Honor. As to the case itself, I have discussed this matter with my client.
Can you hear me?
I respect.
Yes, we can hear you.
Hello?
Hello, can you hear us?
Yes, now I can. Now I can, Your Honor. Now I can. Good afternoon,
All
Your
right.
Honor.
Good afternoon, sir. All right. You want jury final settlement conference?
Yes, please, Your Honor. And then if I may address an aspect as to bond briefly.
All right. Jury final settlement conference in this case will be set for August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person. Yes, as to bond.
Thank you, Your Honor. So Ms. Perrine covered this hearing for me last week when it was in front of, or not last week, 2 weeks ago when it was last in front of Your Honor, rather. And I believe the request was made for Mr. Lloyd to discontinue testing. To my understanding, it was denied at that time just to see that his levels, I believe, of marijuana were coming down. It is my understanding he has not used since his arraignment. The allegations in this case do not involve any sort of alcohol or drug use of any kind. And I would ask, given my client's expenses to pay, he has to pay each time he tests, and having to come, he does not reside in Washtenaw County. He hasn't had any bond violations to my understanding, and we are just asking that the testing discontinue.
Yes. Send us some level. Is there a response from the people?
Yes, if. One moment. As long as he's clean or the levels of marijuana are coming down, then we would have no objection.
All right. So, Mr. Lloyd, you're going to have to wait online. We're going to try to get those from community corrections. Hopefully we'll have them momentarily, and I'll call your case back up. Okay.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court does call the case of people versus William Fridge.
Pretty clear on behalf of the commission, Mr. Fridge was scheduled before the court for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance. Mr. Fridge did fail to appear for his last review hearing a couple weeks ago. Mr. Fridge was in contact with my office. I got him set up. He's working and got him set up with a payment plan that he can manage and has been reporting to me. Given that he's in compliance with that, probation is asking that the court indicate that he paid $125 per month beginning July 25th. He recently made a payment to the court, as noted, that he continue all of the terms as previously ordered, with the next review hearing date being set September 2nd, 2025 at 1 p.m.
And Ms. Flip, you're going to communicate this if I order it to him?
I already did, John.
You already did?
Yes.
Assuming that's what I was going to do.
Correct. I told him that was my recommendation. And he knows who makes the final call. Mr. Fridge does.
But nobody else does, it seems.
Oh, he knows.
No. All right. The court will, without objection, order that the defendant pay $125 per month beginning July 25th, 2025. I'll continue all terms as previously ordered. I'll set his next review hearing September 22nd, 2025 at 1 p.m.
Thank you, Your Honor.
While we await community corrections, court will stand in recess. Everybody can remain seated. Are we all set?
Yep, we are.
All right, we're back on the record in the case of the People versus Lloyd. Mr. Lloyd?
Yes. Yes, hello?
Yep, there you are. Okay, we received the results. Regrettably, you missed a test on June 25th.
I missed the test on June 25th.
Yes, sir.
I didn't know that.
Okay. Well, and your attorney, Ms. Pate, had indicated before we came back on the record, she was unaware of that also. It's unlikely that a violation, although I can't guarantee it, it's unlikely that a violation will be forthcoming, but you may want to contact community corrections to set up new testing.
Okay, today is my testing today. I'm actually on my way there now. Because today they called my name.
You're what?
I'm actually on my way to test right now. They called my name today, just now.
Did they? Okay. Yeah. So go over and get the test, and then your attorney can maybe file a motion with the court, but I'm not going to do anything on this today.
Okay, and I have another question too, Your Honor. When would I be able to first face my accuser?
Do what?
Mr. Lloyd, we discussed that on the phone. Your next court date is August 8th.
Oh, wait, you're right. I forgot. I'm sorry.
Get it?
Yep, I got it.
Okay.
All right, and then Janine and Michael Baker.
All those kind of business for the court draw near, the Honorable Judge.
Good afternoon, sir.
One moment. As long as he's clean or the levels of marijuana are coming down, then we would have no objection.
All right. So, Mr. Lloyd, you're going to have to wait online. We're going to try to get those from community corrections. Hopefully we'll have them momentarily, and I'll call your case back up, okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus William Fridge.
Mr. Fridge was scheduled before the court for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance. Mr. Fridge did fail to appear for his last review hearing a couple weeks ago. Mr. Fridge was in contact with my office. I got him set up. He's working and got him set up with a payment plan that he can manage and has been reporting to me. Given that he's in compliance with that, probation is asking that the court indicate that he paid $125 per month beginning July 25th. He recently made a payment to the court, as noted, that he continue all of the terms as previously ordered, with the next review hearing date being set September 2nd, 2025 at 1 p.m.
And Ms. You're going to communicate this if I order it. to him?
I already did, Your
You
Honor.
already did,
Yes,
assuming that's what I was gonna do.
correct. I told him that that was my
What?
recommendation. And he knows who makes the final call. Mr. Fritsch does.
But nobody else does, it seems.
Oh, he knows.
No.
He knows.
All right, the court will, without objection, order that the defendant pay $125 per month beginning July 25th, 2025. I'll continue all terms as previously ordered. I'll set his next review hearing September 22nd, 2025 at 1 p.m.
Thank you, Your Honor.
While we await community corrections, court will stand in recess. Everybody can remain seated. Are we all set?
Yep, we are.
All right, we're back on the record in the case of the People versus Lloyd. Mr. Lloyd?
Yes. Yes, hello?
Yep, there you are. Okay, we received the results. Regrettably, you missed the test on June 25th.
I missed the test on June 25th.
Yes, sir.
I didn't know that.
Okay. Well, and your attorney, Ms. Pate, had indicated before we came back on the record, she was unaware of that also. It's unlikely that a violation, although I can't guarantee it, it's unlikely that a violation will be forthcoming, but you may want to contact community corrections to set up new testing.
Okay, today is my testing today. I'm actually on my way there now. Because today they called my name.
You're what?
I'm actually on my way to test right now. They called my name today, just now.
Did they? Okay. Yeah. So go over and get the test, and then your attorney can maybe file a motion with the court, but I'm not going to do anything on this today.
Okay, and I have another question too, Your Honor. When would I be able to first face my accuser?
Do what?
Mr. Lloyd, we discussed that on the phone. Your next court date is August 8th.
Oh, wait, you're right. I forgot. I'm sorry.
Got it?
Yep, I got it.
Okay.
All right, and then Janine and Michael Baker. I see Janine Baker there.
Yes, we're here.
Both of us.
Thank you. All right, and then on the other side of that, Matthew Winslow. I'm not hearing or seeing any response. All right, then Samuel Shankster and Kelly Carpenter.
We're here.
There, I see you logged in there. Thank you. And then Danielle Johnson. Is Danielle, no, there's a Danielle Brown. If Danielle Johnson here.
Your Honor, it is Danielle Johnson. Yes, I'm here.
Thank you. Now you're, I'm not sure you're fully logged in. You're not visible there. You've got a grayed out screen.
Yeah, my camera isn't working, sir.
You work on your connection. We'll get to your case shortly. All right, Tana Brock, B-R-A-A-K. No. Brianna Olson. No response. All right, Lavada Beach. Thank you. And Trina Belt.
Okay.
Okay, and you're logged in as an iPhone. Can you change your login to your actual name?
Oh, sure.
Okay. All right, I've got several cases where both parties are present, and then a couple where there's only one party present. So I'm going to deal with the one party cases first. Those will go pretty quick, and then I'll get into the cases where two parties are present. So starting with the one party case, Huffman versus Simmons. Kelly and Brian Huffman. Seat here. 24-201. And that is a motion to renew a previously granted and pretty close to expiring order. All right, do we have a late arrival for Todd Simmons? Got a note here from the clerk that Todd Simmons may have checked in. It's possible that might be a two-party case after all. All right, Mr. Huffman, I'm going to have you stand back where you were, and I'm going to call the other one-party case. And that is going to be Janine and Michael Baker. So Janine and Michael Baker versus Matthew Winslow, 25-146. And we've had no response yet from Matthew Winslow. And then looking at the record here, I do believe this order was served on Matthew Winslow.
Yes, it was previously served.
Yeah, it looks like law enforcement served this on June 3rd by personal service. What did they serve? All right, that was okay. All right, well, it looks like it's properly served and there's no response from Matthew Winslow, so I'm going to grant your an extension of your temporary anti-harassment order.
So, excuse me. So we're just getting another temporary one.
It's going to be an order that lasts for the full term, which is 1 year.
Okay. Thank you for clarifying.
It's going to be on the same, it'll have the same provisions in it as your temporary order, but it will just have an expiration date of 1 year from now.
Okay.
All right, Ms. Baker, I've signed the extension of your anti-harassment order till June 30th of 2026. And the court clerk will send you your copies of the paperwork.
Thank you very much.
You're welcome. Okay. And let's go back to that Huffman versus Simmons case. Let's just take that matter then. So Mr. Huffman, I'm going to address your motion to renew your order. Okay, so this order was previously granted July 8th of 2024. It's due to expire July 8th of 2025. You filed a motion to extend that. And I'm just going to check and see if that's been served on Mr. Simmons. Don't see that it has. I have a notice of hearing, but I can't tell if that's been served. So were you able to serve notice of the hearing on Mr. Simmons?
I took the papers over to Thurston County Sheriff's and they said they would deliver it.
Okay. And they may have done that. If they did, they haven't returned the service to the court yet, so we don't know. So, okay, there's a couple options here. You can go check with the sheriff's office and see if they have a return of service that they just haven't given to the court yet. And if so, then we'll, address that. And then the other thing is that I can extend this for another 2 weeks, give another opportunity to serve or another opportunity to prove that service already happened. And then if it has, then your order can be extended or renewed.
Okay, so I have to go over there.
Yeah, why don't you start by checking with them and then let me know what they tell you. Because it's possible they did serve it and it just hasn't been filed yet. And if they could file it, we'll be able to take your case right away.
So can I go over and come back?
Yeah, absolutely. Okay. Yeah, I'm going to be in here doing some other cases, so you can just come right back in and let me know what they tell you.
All right, thanks.
Okay. And all right, so we're going to go ahead with some other cases where both parties are present. Okay, let's start with Shankster and Carpenter versus Johnson. Okay, that's number 25-187. All right, this is Carpenter and Shankster's petition for anti-harassment order against Johnson. All right, so I'm going to tell you a little bit about how this is going to go, and this will apply to every case where we have a hearing this morning, so this applies to everybody. In these cases, I'm going to call the case, I'm going to swear the parties in, and then The petitioner will present their case first. The petitioner is the person who initiated the case by filing it in court. I'll listen to what the petitioner has to say. Then after that, I'll listen to what the respondent has to say and make a decision as to whether to issue an anti-harassment order. It's the petitioner's burden to prove by a preponderance of the evidence that they're entitled to an anti-harassment order or a protection order. During the time that the other party is telling me their side of the case, I'm going to ask that if you hear that other party say things that you don't agree with, that you don't believe are true, to not interrupt them, to just let them tell me their side of the case, because I'm going to give you the same opportunity as well. So when you tell me your side, that other party won't interrupt you either. I may need to ask you questions once in a while just to make sure that I understand what you're claiming or what your defense is, or if I need clarification. And then I'll tell you what my decision is, and I'll explain to you why I made the decision that I did. So the other thing I'm going to ask you to keep in mind is that mostly I'm going to decide these cases based on information that you filed in writing, if you filed in writing. And then the testimony or the statements that you give me here today orally, you don't need to repeat the things that you've already said in writing. If you've made a statement in writing, if you filed that with your case or in response, then it's already part of the record and you don't have to say it again in order to kind of make it real. So keep in mind, I've already got those and I've read them. So, all right, we're going to get started with Carpenter versus Johnson. Carpenter and Shankster versus Johnson. Can I have the parties raise your right hands, please? All right, and do each of you swear the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
I do. I do.
So, Carpenter, Shankster, you are the petitioners here, and go first. Go ahead.
Thank you. So the reason why we're asking for this order, we did provide quite a few, statements with the petition to begin with. But basically, we've lived in our house for maybe 6 or 7 years. During that period, we never had a problem with our neighbor at all. We even, I would babysit her kid. Basically, they would, her kid would come with me to work, hang out with my boys. We never had any problems at all. I became mayor of the town of Bucota about a year ago now. And since then, the town has had some, in my mayoral or work type duties, the town has had some issues that required my neighbor Danielle's water to be turned off due to lack of payment. There's no way that I personally can turn her water back on, but it's gotten to the point where, we've had a 2-week reprieve, which has been really nice, but I haven't even been able to go out. My son will go out to the car, and if Danielle's out there, she will yell derogatory things. And we've submitted evidence from our recording, our cameras, showing that, we can't go outside without her yelling at us, basically. And it's all really inappropriate things that my son shouldn't have to hear me be called, my husband be called. And all while I can't change what the town has decided to do based off of, my neighbor's actions. So that's why we are requesting for my husband, me, and my son, the no contact order.
Okay, and I did read that in your petition and the documents you submitted in support of that, and mostly in the form of texts. I think there was one video and a image as well. Okay, is there anything else from either of you?
No,
you said it all.
All right, then, Ms. Johnson, it's your turn to tell me your side of it. I don't think you submitted anything in writing, so just, this is your chance to tell me your side of it. And you're currently muted.
Okay, sorry about that. So I just want to say that, first of all, the last name is not Johnson, which they have filed it under, and I would like to say that the reason I contacted her on her personal phone was because I've gone to the town hall and they've told me that they can't help me or to call their lawyer, but they won't give me the lawyer's name. And when it was a hot day, I have the right to ask that my water be turned on, as well as my water has been paid now. And I'm not even allowed to go down to the town hall because it's where she works. But my problem with the whole situation here is in her statement, it states um, that she was out walking and my husband pulled a gun on her. And my husband's been incarcerated in Eastern Washington since February of 2024. His DOC number is 745-862. So that whole situation there is irrelevant. And I'm fighting a foreclosure right now that was illegal. I'm going through a lot of things right now, and not having water and this whole situation is not, it's not all right. I have a child in the home, and it's not right. And I can't even pay it. They won't even let me pay whatever's left on it. So, yeah. And I've never said anything directly to them or said, hey, this person or that person. I mean, I could have been talking to anybody. Never directly to them did I say anything, other than when I asked her to turn my water back on when it was hot, and asked her why she went down to the neighbor's house and asked them to call CPS on me. But that's all I have to say.
Okay. Do you prefer to be called Miss Brown then?
Yeah, that is my legal name. And
okay. All right, thank you. All right. Well, in a case like this, I need to decide whether I'm persuaded by a preponderance of the evidence that harassment has occurred. And, you know, generally harassment's a course of conduct that's directed at a specific person that is harmful to that person, that seriously annoys or alarms or harms them in their mental or physical well-being, and it doesn't serve any lawful purpose. And that any harm that the person suffers is what a reasonable person under those circumstances would suffer. And so, you know, I'm going to take into account the fact that the petitioner here holds a political office, and that people who are in political office are expected to have to deal with constituents who might not be happy with them, and there might be, you know, heated words, there might be things said that are, you know, pointed and sharp and critical, and that's all part of what it means to occupy a public position sometimes, especially one, a political one. And so that's certainly something that comes with the territory, so to speak. But on the other hand, there are lines and boundaries. And so even if a person is in a political position and you know, they're just out living their lives and running their own business and doing the normal things that anyone would do, and then being subject to, you know, basically being accosted on the street or accosted outside of the confines of their job and berated or, you know, threatened or tormented, especially about official business. I mean, this business with whether the water is shut off or not is an administrative act that is done in a proprietary capacity by the city utility. And then focusing in on the mayor because the mayor is just the most obvious person who represents the city, and then getting, you know, in a position to torment her in her off hours and make her, I can't see this as anything other than an attempt to intimidate her to get the water turned back on, which is happening apparently because you don't qualify to have your water turned back on by the normal process. And that's not okay. That isn't okay to do to anyone in a political position. Even though, as I said, people in a political position are expected to kind of have a tough skin and take a lot of criticism more than probably the average person. But that's not what this is. This is unreasonable. It's not something that a person in a political position should have to tolerate, especially because it's clearly being done as an act of retaliation for administrative acts that are done by the city. And so I do find by preponderance of the evidence that harassment has been proven here, and I am going to issue an anti-harassment order, which I believe will be like the temporary order that was issued a couple of weeks ago. In other words, the provisions of that would be the same. All right, so that'll be my ruling. I'm going to commit that to writing, and then both of you are going to get copies of this order.
Your Honor,
I'm sorry, who was that?
that was me. I was just,
Yes.
she works at the town hall, so I can't go down there.
I'm going to address that separately, so just hang on. All right, now I've issued this anti-harassment order that's going to be effective through June 30th of next year. And Ms. Brown, to address your concerns, which I think are legitimate, I've made an exception in the order to the exclusion provision, which is in paragraph 8D of the order, that the respondent, that's you, Ms. Brown, may conduct business and attend meetings at Bucota Town Hall.
Okay.
All right, that's the order of the court. The court clerk will send copies to both of you for the end of the day.
Thanks.
Thank you.
Thank you.
You're welcome. All right, Mr. Huffman, did you get any answer from the sheriff?
They told me that the officer had the paperwork and had to return it, but obviously they have because he's right there. So delivered the paperwork to him.
Oh, he's appeared?
Unless they
Oh,
delivered the
okay.
paperwork.
All right, so Mr. Simmons is here. Okay, got it. Let's call that case then. Okay, yeah, come on back up, Mr. Huffman. So Mr. Simmons, are you joining us for this renewal hearing of the anti-harassment order that Mr. Huffman got last year? All right, Mr. Simmons, your connection is not complete. We can see you, but we can't hear you. And usually when that happens, the way to deal with it is to just log off and log back in and hope that the connection works that time. I'm going to call another case while we're doing that. All right, next case will be Beach versus Belt, 25-189. And you are Miss?
I'm Levada Beach.
You're Miss Beach,
Yes,
okay.
correct.
And then Miss Belt, there you are on the screen. And can you hear me okay, Miss Belt?
Yes, all right, I can.
Very good. Okay, just a moment here while I open up my file. Yes, okay, so Miss Belt, I see that you were served with notice of the hearing and a copy of the petition.
Yes, sir.
Are you ready? You ready to go ahead with your hearing today?
Yes, sir. Yes, sir.
Okay, very good. So just like the last case, I'll swear the parties in and we'll get started. So can you each raise your right hand, please? And do you swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Yes, sir. Yes, sir.
Okay, all right, and Ms. Beach, you're the petitioner in this case, so you can go first.
I pretty much put it down as clear as I could. I just would like to have the restraining order to cut any access of interference or threats from her or intimidation or games. I don't want any more to do with it.
Okay, just a second here while I advance up to your petition. So I'm just reminding myself of the allegations in the petition, and I mean, it's not clear to me what part of this sort of series of interactions is harassing to you? I mean, what's the part of this that's causing
The
you
part
problems?
of her contacting men that I am seeing that she absolutely does not know and engages in conversation, which has been verified. I've spoken to them or to him, and he implied that he thought it was his cousin. The other part was she actually sat and described exactly how she was going to have my son put down to my face. And I was appalled. I've never had, I am aware that her daughter and my son had a relationship and it was not well. That was part of how this conversation was brought up. She had never met me before, but spoken to me once on the phone. It was not a pleasant conversation. I had reminded her of this when I was at her house. I was trying to befriend her, get to know her. I have only been in her home and engaged in conversation with her 4 different times. But in the short time that I have interact with her, I hope I'm saying this right, I can see why her daughter has fear. And I don't want any part of it.
Okay. Is there anything else I need to know?
No.
All right, Ms. Bill, I'm
Yes.
going to hear from you. And I also, I read the petition that Mitch Beach filed, so I guess I have a little familiarity with that, but I don't think you filed anything in response. So it's your chance to tell me your side of it.
Okay, so I didn't file anything in response because she has only been to my house once, and that was for maybe 10 minutes when her son and my son, were outside while my son was riding his bike. I very, very little spoke with her because I just don't have anything to say to her. As far as her saying I harass her, I don't have her friends on Facebook where I'm not friends with her son or my daughter. I don't have her phone number, his phone number, and I've blocked my daughter's phone number. So, and I don't even know where they live. And I don't know who this person is that she is speaking of that said he thought he was my cousin. I'm a recluse. I don't know anybody. I work and I take care of a drug addicted baby that was abandoned 8 years ago, who I have full custody of with, yeah. So I don't understand. I mean, what she's like, when I got these papers, I'm sorry. I don't know how to say this politely, but I felt dumbfounded and just dumbed down because I didn't understand any of the wording that she put on here because none of it made any sense because none of it's true. I don't have people like that in my life. I don't, yeah, it's ridiculous. I don't deal with her son because her son has his own addictions and I don't want that around my son, nor do I want my daughter's addictions around here. So that's why my daughter and her daughter went to Leveda's, I guess. But as far as anything of this nature, no, it's all completely false allegations.
All right. Anything else I need to know?
No. That's it.
Okay. All right. Thank you. All right. In this case, the fact is I don't see harassment here. I don't see that harassment's been proved in any way. I don't think any of the elements of harassment are met, certainly not by a preponderance of the evidence. So I'm not granting an anti-harassment order here.
So who do I do for protection?
If you feel like your safety is at risk, then you should call 911.
Thank you.
I've signed an order consistent with the ruling that I just gave, and both parties will be sent copies of this by the end of the day.
Thank you.
Thank you.
Thank you.
Have a nice day.
And we never got anything back from Mr. Simmons?
Trying to join again, and I let him join, but.
Give him one more chance. I've got one more hearing to do here, so. This next case is going to be Meyer versus Adams. So Ms. Meyer and Ms. Adams, right? Okay. I've got two cases with you both here. So in the first one, Ms. Meyer has asked for a contempt finding for violations of a previously granted order. And then it looks like Ms. Adams has filed her own independent petition subsequent to that. And the hearing on that is set for today. I'm going to handle these kind of at the same time since you're both here. So I'll just hear what you both have to say and make a decision on both issues, the contempt issue that's been raised and on whether or not there's going to be an additional order granted. Okay, makes sense?
Yeah.
Okay. The contempt issue is a little bit different than the hearings that you've seen happen up to now this morning, but it's also similar. So just sort of to frame that up, Ms. Meyer has brought allegations that Ms. Adams has engaged in conduct that violates the restraint provisions of the anti-harassment order that was issued earlier. And she's asking the court to make a finding that that occurred and to issue a contempt order. So that's a little bit different than granting an order, but the standards of proof are basically the same. So, all right, I'm going to have both of you raise your right hands, please. Do you each swear that the testimony you give in these matters will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
All right, so I'm Ms. Myers. I'm going to let Ms. Meyer. I'm going to let you go first.
Okay. So I had filed a anti-harassment, I want to say it was like May 19th now, and I had it granted. And since like right after that, a lot of things escalated to the point where I've had to talk to my landlord and I've had to call law enforcement. Law enforcement has been a bit harder because when I've contacted them, they've told me several times that my anti-harassment order wasn't served. So then I've had to call the court to get it to like verify to say like the law enforcement is saying that my anti-harassment isn't served and they're telling me it has been served, we have sent it. So then they've had to contact law enforcement again to say like this has been served, and then I've had to call law enforcement to like confirm and say the court has called you and sent you that this anti-harassment has been served. And because that was such an issue for me to even get like figured out, there have been multiple times where Cindy has violated my anti-harassment. And according to the cops, each time that I call them is a isolated time. So it's like I can't refer to it again. So it's like something has happened and I've had it on video where she's contacted me like directly. I can't like call them again and say like now can you help me because of my anti-harassment. It's been more along the lines of them coming and say like first they were like you need to get video proof because it was more verbal. So I understood that. I was like okay then. So then I would have video and then they would say well, now I don't have anything here that says that your anti-harassment served. So it's just kind of been an ongoing thing. So like the next step, I talked to a lawyer. The next step was like contempt, and they said just to give the information that I had. There have been incidents where she's yelling and screaming outside my door to the landlord, and I had a video of that, but the lawyer said because it wasn't directed at me not to that it wouldn't be something would that I could show the court, but I wanted to show it just because I wanted you to hear like how she talks and how she's screaming at like someone, even the landlord. And there have just been like situations where the maintenance, even my landlord has come to me and said that she said these things about them to the point where I'm like, that's how it is for me, where she's doing harassment to me directly. In my in the evidence that I sent you, there's videos, or not videos, of also photos of her trying to break into the laundry room where the knob and the lock have been completely broken out. And I've called the landlord, and he's even verbalized and said, oh, she told me she was going to do this, and I can't believe that she did it. And so then he took access of the laundry room from her because she messed with the like construction of the vent, and she's like screwing things. And so he took that away from her, and I feel like that kind of escalated it. But mostly it's been just about me, my home. I feel like anxious even being here. My landlord has given me keys to another property that he has, that when I'm not feeling safe, I could stay there. I can't live there because it's a property he's selling, but he has given me keys because he knows I have my son, and he knows how like unstable she is, because he doesn't want me to be around it. Um, it's been like an ongoing thing. The landlord has verbalized to me that he is working on like an eviction, because even this harassment has gone to the point to him as well, because this has nothing to like pertain to my case, but I just want to say it because it also like shows her unstable behaviors, because he came to me after talking to her and said that she's implying to him that that she was going to say that he touched her inappropriately when he didn't. So it's just been like an ongoing thing all the way around. And for me, it's just been like I'm trying to keep my son in a stable and safe environment. Luckily, all the times that she's done stuff, my son has not been present. And I've been able to have him with his dad, or I've been able to have him at that property just to make sure that he's not here when she's like yelling or there's something going on or the cops are here. But it's been like a situation where it's just caused so much anxiety, and I don't even feel like calm or safe like in my home. So it's mostly about like having my son here. And I feel like in the last month and a half, he has barely even been here because I don't want him around this environment.
All right, well, let me hear from you, Mrs. Adams, both on the issues that Ms. Myers brought up about potentially violating the order, and about your own petition for an order against Ms. Myers.
Could I ask you first, because I did go over the what was filed on both the cases last night, and I didn't see the police reports. Did you see any of that? Because that's kind of like what I'd like to focus on, if I may. I can provide you with a copy so we could follow along a little bit, and I'll try to go through this pretty quickly.
These are police reports?
Yeah.
Okay. Have you given those to Ms. Meyer?
Yes, it's all been.
Let me see what you have here.
It's all been filed. I highlighted.
You might have filed those. I've got two cases I've got to take a look at.
I didn't see it myself, and I searched and searched, and I didn't see videos of where she's saying I contacted her directly, which I haven't, and the landlord verified that I had not as well in one of the conversations with Officer Paul. I just would like to go over each one of these a little bit briefly.
Lacey police reports. All right, let's see. Ms. Meyer, did you get these Lacey police reports? Well, they're not really police reports. They're abstracts of
Yeah,
calls.
I've seen like some of them. I didn't really, it didn't, I mean, it's showing that like the police officers came here and like verbalized, but it's not showing, I'm not really understanding like how that really pertains to like me. Cause I mean, it pertains to me, but I just don't, I read them, but I'm not really seeing like.
Well, my question isn't whether you agree with them
Oh,
or think
okay.
there's any merit to them, just whether you know about them. Have you
Yeah,
had notice of these?
I seen the ones that are in the documents that she served me.
Okay. I don't see those here. Let me see if I just missed them. I found them. Okay. So yes, you did file these. They're in your petition, and now I found them. So, okay, mystery solved.
I have extra copies. You
Yeah,
can go.
no, that's fine. I mean, I
Were
appreciate
you
that.
able to go over them, or we could go
Yeah,
over?
these are just CAD logs. These are recordings that the 911 center makes that sort of outline the basis of the call and who responded and sort of like a skeleton version of events and then the disposition. So yeah, they're not really police reports so much as they're just sort of documentation of contacts and actions taken by law enforcement, taken by the 911 dispatch center at TCOM. So yeah, I'm very familiar with these. I know exactly what they are.
I'd like to be a little more specific on the charges or the accusations. So Bianca was granted a protection order on May 19th, and May 24th, it started with her calling the police. Yeah, I was doing my laundry and I did it up till midnight. But she called dispatch and told them I was yelling and pounding outside. And the officer came and she said she had a video of me making excessive noise. And I was just doing my laundry, and he listened to the video, and he made a comment here that that there was nothing unusual about, that he could barely hear on her video of me opening and closing the machines. He also noted that there was no sign of malicious intent. Basically, what I perceive is happening here now is because this went on for a week. It was every single day. I would go to the store and I come home and I was greeted by two police officers at the end of my driveway over the knob in the laundry room. The day after, or I think it was the day after the next day, she was so upset about Officer Gutierrez not arresting me because I was taking so long to do my laundry, that the next day in the report that's I'd use the last three numbers of the police event 020, she called him. She called and got him. He was working at the time, Officer Gutierrez, same officer that came out and demanded. It says she demanded that I have have Cindy arrested. And then he goes on to say, then and he just responded that she was just doing her laundry, and that he doesn't hear anything on the video of anything but that. And then she wanted to speak to his supervisor. It seems to me that he was, I can't say how another person feels, but he went on the next page to that and said he's going to write a report and refer it to the prosecutor because of not my actions, but her actions, demanding that he have me arrested for doing my laundry late at night, which is not uncommon for either one of us. We live in an odd situation with the houses that's been divided up into a duplex. Then let me see. So the thing with the vent, I mean, she's gone so far as to accuse me of there's a vent, it's a hole in the laundry room, and she's gone so far as to say that I took the vent off and I was peering through her house while she's sleeping on the couch, and she just suddenly wakes up and sees me staring at her. I mean, I don't even know what to say about that. I did try to cover the vent because the officer had told, I'm sorry if I'm being a little loud. I get a little loud when I get upset. But the officer had told me she was using the vent that goes into the laundry room. It is on the other side of her wall is a kitchen. And unfortunately for her, that the laundry room is she could hear the sounds more into her kitchen than the way the house is situated. I'm further back, so I don't hear it as much. Occasionally I do, but if the buzzer or something. But but for her, you could hear it. So, I mean, it was twofold or more than that, that I even covered it up, but she didn't like the idea that I covered it up. I covered that vent up because she was using it to videotape me. You know, this is the privacy of my home, even though we shared the laundry room. She went so far as to have her friend, Tristan Chapin, come over and tear off the frame of the door, which is the door to my entrance into the laundry room. Hers is from her kitchen. We have separate doors. And that door has a lock on my side, keeping her from entering my unit and me vice versa. So her not liking that I took so long to do my laundry and whatever she thinks she went on to say I was harassing her because I'd taken so long. I was washing everything. But mostly because the officer wouldn't arrest me the next day for that she went so far as to have called her friend over and he tore the door frame off on this side and used it of my door and used it to board up the door so I couldn't gain entrance into the laundry room. In the meantime, it was anyway, we talked about the vent thing. So there was a point so I was texting the landlord and he said that he would, because the landlord did come over at some point. He came over and him and I, as soon as he pulled up, she comes running out. I'm by my car. I'm walking out the door, but I'm still by my car. And I have not made any contact with her whatsoever. I have done my best not to. She has tried to antagonize me. She has tried to coerce me into situations to talk to her. I don't even know why she has a protection order. The very next day, this happened on Saturday with the laundry. The very next day on Sunday, I'm out washing she has a garbage can, as she assigned me this garbage can, and she has this one. And I'm cleaning my garbage can. This was the very next day. It only took her 4 days to take that protection order and use it to harm me with, and I knew that she would. So I'm out I'm cleaning my garbage can out, and I'm washing my car. And she comes out, she pretends to she's going to put something in her trash like this. And then she walks over, and it's so petty, it's ridiculous. She walks over and she's looking at me, and I'm standing by my car and I'm getting ready to wash my car because I rinsed out the can, but I have some trash next to the can because I was still working on that. And she walks over, she looks at me and she grabs she is like this. And she's watching me the whole time, and she grabs the tip of the garbage bag and goes like this. And like as if there's this invisible line, and don't cross it on the gravel. So for somebody that's so fearful of me, why are you putting yourself in harm's way? If I'm such you think I'm going to do something, but you come out and you stand there, you're not 10 feet from me. She did the same thing with her son. She sent her son out to play ball in the driveway, and I've lived there for 15 months now, and she's lived there a couple months longer. And the situation is the house has been divided, and I'm in the back and she's up here in the front. And the driveway is, yes, she uses it because she has a parking space here, but I mainly use it because I have to go here, and nobody is allowed to park in the driveway. It was stated from the beginning by the landlord, though she had tried to do that at the beginning, and she has not done it since, once I told her I don't want to be blocked in, but that went on to another story here. But so I felt she said, from what I could tell, I hear her son out bouncing the ball in the driveway, and I'm inside, and I'm not going to go outside because the protection order has his name on it too. And so I have a window right there. And so the curtains open a little bit, and I noticed her cat was laying in a planter box, which, I don't care about the cat, that's what they want to do. And so I saw the boy, and he waved at me. And for one thing, he's never played out there in the 15 months I've been there. And he's never waved to me. And so, but I could tell he was about 10 feet behind my car. And so she has this little strip of sidewalk. And I could tell by the way he was acting, he was taking his orders, I don't want to say orders, but instructions of how to act with me, because he would look over her and then look over. I couldn't see her, but you could tell when somebody's interacting with somebody else. And so, but for him to wave, because I felt that she told him to go out there, and actually, I know this sounds a little bit crazy, but to wave at me to get, because she's calling the police every single day over petty stuff, and they're saying she hasn't violated her order. She's calling the police back and saying, well, what does she got to do to violate her order? Can I help her? She's trying to help me violate the order. That's where the coercion comes in. And as far as cars, this picture part, she had her friend parked right behind me at 9 o'clock at night. I want to go to the store before they close. And she's saying, and yes, I did honk to have her come out. She never did come out, and police had to come, but the police are, so what I believe is happening here is she is using the courts to try to get me arrested and to turn around, and because the police are saying she hasn't done anything wrong. There's no intent. There's 3 times for sure in these police reports that the police are saying no. So she says, oh, well, okay, I can't get them to do it. Maybe I can get the judge to do it. And then by that, she's going to go back and she's going to tell the landlord, okay, he's going to have her arrested. Now let's get her evicted. And it even mentions that she had that conversation with a police officer getting her evicted. She's telling them, she's telling the police, it's all written in here. She's telling the police what she's going to do. I'm going to make it. She tells one police, I'm going to make it where she doesn't have access to the laundry room. She's telling them beforehand, and they said, I'm going to make it where she gets evicted. So that's the gist of everything that's been going on. For that last week. I mean, this has been going on a little bit longer.
All right, I understand.
Okay. And I apologize. I am very nervous, and I feel like I'm in lockdown in my house. I've been scared to death. I talk to my daughter about it all the time. I talk to my brother who lives in Florida about it all the time. And I've got my curtains closed. I'm afraid to go out in my car, and she's got, watching me all the time. And anything that she has, I'm gonna lower my voice, anything that you may have read in there, because I have gone over some things, she has submitted, she says videos, and my restraining order, though it's temporary, and I'm seeking a more permanent one, says that she cannot continue to videotape me. Well, but she keeps saying I'm videotaping her. So anything that she has presented to the court that's you're reading about, I've looked at the dates that she's talking about, and they're before my restraining order of May 19th. But she's what I see her doing too is misleading. She's misleading the police. She's lied to Officer Paul, saying that I made contact. I looked for that video. She was saying that I made direct contact. I want to see that. Anyway, I have said,
Right.
I have not made direct contact. I have tried to avoid her.
Yeah, like I said, I understand, and I think you're kind of hitting the point where you're repeating things that you've already said, and so it might be time to stop here. All right, I'm going to tell you my ruling on both things. First of all, the contempt on the 25-133. I don't think contempt has been proved here. There's not a substantial basis to find factually that there were intentional violations of the order. I went back and reviewed the order, and the prohibitions have not been violated as far as what I can find here based on the filings, based on the testimony. Not satisfied by a preponderance of the evidence that occurred. And then, so I'm going to deny the motion for contempt. And then the petition under 25-160 to issue an order, basically in the other direction. I'm going to deny that as well. I know that there's difficulties introduced into this relationship by the fact that an anti-harassment order exists, but a person making reports of violations of an order and calling the police is not going to serve as the basis for harassment. So Ms. Adams, I'm not going to do that. Now, you have the right, Ms. Adams, to request the court by filing a motion to do this, to review or rescind the order that was issued on May 19th. That's not before the court right now, so I'm not making any rulings on that.
No, could you tell me again why you're not? Your Honor,
Because you
she's
have
not
to-
gonna leave me alone. I've been a nervous wreck. I can't take anymore. I want her to stay on her side and I will stay on my side. Please don't talk to me. Don't have nothing to do with me. Now I have to go out to the laundromat all the time. I have a broken wrist that's still trying to heal. And to have to lift all the laundry, it costs $150 a month, which the landlord is having to pay because of her selfishness. But Your Honor, if I don't have, because she has the restraining order, so she has or thinks she has the upper hand. I don't know how I've not proven that she has not harassed me since she got that restraining order. She's going to keep coming after me. So what is it I didn't prove?
You have to prove by preponderance of the evidence that harassment occurred, and that has not been done, particularly by showing that she's attempted to have the anti-harassment order enforced. You find that disagreeable, but that doesn't serve as the basis to prove that she's engaged in a pattern of harassment. That is
calling the police on me every single day. Calling the police on me every single day is not harassment.
Now, like I said, the order itself, the order that was issued earlier, I believe that by Judge Meyer, you can ask the judge to review that if it's having consequences that he needs to be aware of to make modifications to the order. If you file a motion like that, the court may very well consider it.
Let me write that down. Okay, tell me again so I can write down because I'm not going to remember it. And directly to him?
No, to the court.
But not. Okay, what do I say now?
I'm not going to tell you what to say.
No,
I'm just
I know.
telling you that there is a procedure by which you can ask the court to review an order that's been issued and make modifications to it. You just have to make the request and support it in writing, and the judge will determine whether that merits a hearing.
So, well, I don't know why I'm not getting this. Review an order that's been issued. I don't have an order now. It's my temporary order.
The order that was issued in 25-133, the one that restricts you. If
Right.
those restrictions are causing you problems, you can ask the judge to review that. Okay. All right, so I've denied the order under 160. I've denied the contempt under 133. There are no written findings to accompany the denial of contempt under 133. That's done on the record orally. There's a written motion denying the petition under 160.
Your Honor, can I say something?
All right, what would you like to say?
There was also another order that she tried to serve on me that was not the anti-harassment that she was trying to serve on me. There's another one where she tried to serve like contempt. Is that also getting dismissed? Because she's saying that
I don't have that in front of me for a hearing, so I don't know what you're referring to, but the only action that's been taken is what I referred to.
Okay. Okay.
All right, Ms. Adams, these are your copies here, and that'll conclude your hearings for today.
Okay.
All right, now let's see if we can get Mr. Simmons back. I see you've logged back in there, Mr. Simmons. Can you turn on your microphone?
Yeah, there you go. Can you hear me?
Okay, now I can hear you. I can see you. And I've got Mr. Huffman here who's been patiently waiting. So we're going to take this one up. Again, this is 24-201. Okay, and as I said earlier, but you weren't here to hear that, Mr. Simmons, this is Mr. Huffman's motion to renew the previously granted anti-harassment order that's set to expire here in a little more than a week. So Mr. Huffman's asking the court to extend that order in its current form for longer. So before I go any further with that, Mr. Simmons, do you have any objection if the court were to extend that order for longer?
Yeah, I should have been the one that been granted an order against him. Him and all the surrounding neighbors that live around me, they're constantly harassing me since day one, since I moved in 5 years ago. I'm a targeted individual.
Let's refocus here a little bit, Mr. Simmons. I need you to understand the court's not reviewing whether that order should have been issued in the first place. That is a hearing that's been held, done, and decided. That's all in the past. So that's a closed issue. It's done. The issue is the court going to extend that order any further than July 8th? That's the issue before the court.
I hope not.
So I'm asking you if you care if it's extended or not, or it sounds like you do. So
yeah,
the burden, it's a little bit different than an initial petition or these other cases that you've heard today. There's a presumption that the order will be renewed unless the respondent, that's you, Mr. Simmons, shows by a preponderance of the evidence that acts of harassment are unlikely to occur in the future. So since that burden's on you, Mr. Simmons, I'm going to hear from you first, and then if necessary, I'll hear from Mr. Huffman. So can I have you both raise your right hands, please? And Mr. Simmons, do you swear, do both of you swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr.
Yes.
Simmons, on the issue of whether the order should be extended for additional time, what would you like to tell me?
I don't find it necessary. And I would like to be able to go in that direction down that street because I'm an outdoorsman and I'd like just to have access to the mountain there. And with that in place, I can't. I used to be a cyclist and I'd like to be able just to ride my bike up and down the road, and we live on a dead end road and I can't even do that. But
which road is that?
I'm not a person. It's Fennel Road.
That's a dead end road?
Yeah, it just runs into a dirt road which goes into the mountains.
Oh, I see. Okay.
But it's
so tell me why it is you
I'm
can't
a laid
go
back
down that
person.
road. I don't just from the face of it, I don't understand why that's a problem.
Because the restraining order says I can't come within 100 feet from his house, and his house is right next to the road.
Oh, I see. Okay.
Yeah.
Yeah, I see that.
I don't want no problems with anybody. That's the last thing I want.
Second here, I'm going to look some information up. Okay, so that 100-foot restriction prevents you from going down to the end of the road. Is that what you're telling me?
Yes, sir.
Okay. that order currently says. Oh, there. It says 100 feet from the protected person's residence. Okay, I understand. All right, Mr. Simmons, did you want to tell me anything else?
No, that's basically it. I never wanted to have any problems whatsoever, and it's unfortunate that it's been like this. But other than that, just having access just to go to the end of the road would be nice.
All right, let me hear from you, Mr. Huffman.
Okay, so if he didn't want to have any issues, he shouldn't be yelling at his neighbors from his property to get them to engage him. Like he'll yell at us, like if my wife or my daughter's calling the dogs, he'll mock them to try to get us to engage. I was out in the yard doing yard work and he heard my music and he'll start, like mocking it, trying to get us to engage. That happened before last year.
That's not true.
That's when he shot me in the ass with the slingshot. And now within the last month, maybe 2 months, we've heard arms fire.
Mr. Simmons, don't interrupt, okay?
Come from his property.
I'm sorry.
So now that seems as though it's not feasible, not accurate, not or something he should have. And then my other neighbor that's on the other side of him walks her dog up and down the road. And when she heard him firing, she did not feel comfortable enough to pass by his driveway. So she stopped in front of my driveway, which I have on video, called her husband to come pick her up because she didn't want to walk in front of his driveway. So now it's to the point where it's gone from a slingshot. Now he has a small caliber small caliber gun.
Okay. I'm going to allow this order to be extended for another year. I think it's necessary to keep the peace and for Mr. Huffman to maintain the protections he's had under this order. All right, I've extended the order, same terms and conditions as the original order until July 8th of 2026. All right, and the court clerk will provide copies of that to both parties before the end of the day.
All right, good morning. We're back on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And next we have Moran v. Bishop, file 24-9092NZ. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Sandy Jasinski on behalf of plaintiffs.
Good morning, Your Honor. Adam Flory on behalf of the defendants.
All right, and we have today plaintiffs filed a motion for entry of a default judgment on the issue of liability. Defendants filed a response. They also filed a motion to set aside the default and had initially obtained a hearing date at a later date. My understanding is that Ms. Jasinski has waived notice so that both motions are being heard today because obviously logic dictates that we consider the defense motion first. Is that correct, Ms. Jasinski?
Correct.
Okay, so Mr. Flory, with that understanding, we'll proceed first on your motion to set aside the default. Go ahead.
Thank you very much, Your Honor. I appreciate that. Again, Adam Flory on behalf of the defendants. Your Honor, I'm sorry to be before you under these circumstances. As the court is aware, for a motion to be set, a default to be set aside, good cause and a meritorious defense by way of an affidavit of facts must be shown. In this case, Your Honor, when the default was initially entered, I was very surprised because we had filed two answers already, one to the original complaint and then an amended answer to the original complaint. And I knew that Ms. Jasinski had amended her complaint. I stipulated to that relief to allow that to be done. And again, I'm very fastidious, or I try to be very fastidious with calendaring and ensuring that deadlines are appropriately documented. And so I was really completely caught off guard. I pulled apart our entire file, Your Honor, and tried to determine, what happened here so as to lead to this set of circumstances. And one thing that I found, Your Honor, is that we never received a copy of the court's order granting the right to file the amended complaint. I think Ms. Jasinski has stated that she filed or mailed the order. Ms. Jasinski is a very competent attorney, and I'm not questioning that at all. All I know is we didn't receive it. I will say.
Can I ask you a follow-up on that? When I reviewed your motion and the attachments to it, you were saying something a little more nuanced, I thought, that you did not receive a copy through the US mail. And you kept saying that you put on all your signature blocks, the email is not sufficient notice to me. When I look at the certificate of service filed by plaintiff, signed by Ms. LaHaye, dated May 13th, it says that she served you with the order granting the motion for leave to file the First Amendment complaint and the First Amendment complaint and the certificate of service, both by first-class mail and email. So do I understand correctly from your pleadings, it didn't state it directly, but the implication was that you did have it by email and you're saying you never got it by regular mail?
I apologize, Your Honor. I believe that's correct. When I was preparing for this motion, I couldn't find the order by email, but again, I didn't have the proof of service. When I received pleadings by mail, Your Honor, I count on the mailed by email. I count on the mailed backups. And so I searched by Ms. Jasinski's name and by the name of the support staff who had sent me the default, but I wasn't aware of Ms. LaHaye's name. I did not search by her name. And so I couldn't find it, Your Honor, but I think that's probably correct that I did receive it by email. Your Honor, of course, email is not effectual service, and typically it's fine. I enjoy receiving courtesy copies by email as well, and I try to do the same. But because I'm so busy, Your Honor, and just get so many emails, I don't trust myself to forward every single email to my support staff. So that's why I always wait on the mailed copy. And so
obviously. Can I ask you then, so, I don't have data or studies to support what I'm about to say, and maybe the US Postmaster is going to be unhappy with what I'm going to say, but since COVID, my anecdotal impression from both our own court and from what lawyers are telling me and my own personal life, the US mail is not what it used to be, but it still is the gold standard for service. But Mr. Flory, I'm a little flummoxed here about what I'm supposed to do to find good cause if I have an attorney saying, well, my good cause is I never got it in the mail. I did have actual notice of it by email, but that doesn't count. What am I supposed to do with that? I mean, if let's say the email didn't exist and I've got one side saying, hey, I sent it by mail as required, and you're saying I never got it. I don't know what the law is nowadays when the post office is not as reliable as it used to be. What I'm supposed to do with that? Maybe I get to finding good cause if I believe it to be a truthful statement that it was never received on the receiving end, especially here where you were participating in the case up until that point. But I'm struggling with how I get to good cause when it seems that you did have actual notice of it. Help me out there.
Your Honor, I would say a few things. Number one, Your Honor, again, perhaps I should modify this, I suppose, in terms of the efficacy of the U.S. Postal Service, in terms of waiting for the mail copies. But I've not had circumstances where I've just not received it, or that I've received it in a way that prevented me from participating. You know, like I've not had a circumstance where I received mail months later or something. And so, again, Your Honor, I agree that the U.S. Postal Service has struggles on occasion, but in my practice, I found that to be the best way because it is required by the court rules. And again, Your Honor, my staff does not receive all my emails, of course, but my staff does receive all the mailed copies. And so, Your Honor, again, I think that the emailed copy is a courtesy copy, which I appreciate, and I try to do the same. But it's not the effectual service copy required by the court rules. That's the mailed copy. And
I get that. So if they only sent it by email, maybe there'd be an issue. But you're not disputing, are you, then, that you had actual notice of this order?
I don't recall seeing it, Your Honor. I don't recall seeing it personally. So, Your Honor, I can't say whether I saw it or not. I get probably 100 or so emails a day of substantive nature, Your Honor. And again, that's
why. Mr. Flory, I mean, I guess I'm going to encourage you to be super careful about how you phrase it, because when I read your pleadings, reading between the lines, it seems to me that you were saying precisely that. You took such great pains to point out the deficiency of email service. That caused me to believe, from reading your pleadings, that you were saying, I got it by email, but that doesn't count. I didn't calendar it with my staff because we wait for the mailed copy and I never got the mailed copy. So, I mean, if you need a moment to review your email to perform that query again or something, I just want to make sure you're stating accurate things on the record about that. I understood your pleadings to be saying pretty clearly, at least implicitly, that you did get the email, but that's not enough.
Your Honor,
so here's your opportunity to correct me if I'm wrong.
Your Honor, basically, I was just saying that I trusted, we've historically emailed courtesy copies in this case, and I trusted that they did. That's what I was saying. Your Honor, with respect, I just don't remember days and days or weeks and weeks ago emails that I received or didn't. If they say,
you said you checked in preparation for this hearing. You didn't check in your file. You didn't have like a printed copy of it or anything, or
no, Your Honor. Your Honor, I checked by name under Ms. Jasinski, and I checked by name under the name of the support staff who sent me the default. I couldn't recall the name of the other individual. And so, Your Honor, again, for purposes of this discussion, I can check right now, but if the plaintiff's counsel's office is stating they sent it, I'm sure I received it, Your Honor. Again, it's
well. I'll accept that representation.
Thank you, Your Honor.
Right, anything else you want me to know to understand your argument?
Yes, there is, Your Honor.
Go ahead.
Thank you. So, Your Honor, again, when I receive emails, in just as a matter of course, I don't just mean on this case, I mean on every case. When I receive emails, I appreciate them as a courtesy copy. But again, like all counsel, I'm extremely busy, many cases. And so in my mind, I wait for the mailed copy to come in so that dates can be calendared, so that my staff can talk to me about it, so that we can make sure we're all on the same page there. That's why I actually added that provision to my signature block, just to make clear that I, with respect, would not ordinarily stipulate to email service because even though there are deficiencies with the US mail, I have problems with email. I've gotten emails sort of lost before where I haven't received them when they've been sent. And I have been, under circumstances where I get 100 emails a day. It's much easier for me to lose track of an email than it is a mailed copy that my support staff would receive. So, Your Honor, that is one element of the good cause, which again, I can tell the court again, completely candidly and honestly, that I did not receive a mailed copy. And so, and my staff, I thoroughly talked to my staff and they didn't receive it either, have not seen it. So that was one sort of part of this problem, Your Honor. The other part of it, Your Honor, is a personal issue with me. And I went into it a little bit in the brief, and I don't mean to belabor.
Well, I'm not going to require you to get into that here on this record. I saw it in the brief, but that sounded like that was sort of on the timing of that. I wasn't sure how that affected the motion here.
Only, Your Honor, that if I may, only, Your Honor, that I've been out of the office for much more lately. And so, if I was in the office as frequently as I normally am, perhaps I would have caught something where I received an email, but no mailed copy. And so, but, my niece was, I was advised by a doctor at the Flint Children's Hospital that it was life-threatening, Your Honor. And because of that, caring for her, being home with her, I have been out of the office for much more than would be common. And so that unfortunately was a constraint on my time for my practice. And so if I was in the office under normal circumstances where I'm, in the office all the time, frankly, I would have had a better chance to catch or address a situation where I may not have received an order by mail. So that was what I was referencing there, Your Honor. So I would also note, Your Honor, with respect to, and Your Honor, also with respect to the good cause, I would just ask the court to remain mindful that we were participating in this case, Your Honor. We were defending it. We had filed 2 answers. We had appeared at every court hearing. And so, Your Honor, again, I don't think, with respect, I would assert that this is not the equitable remedy in this case. My client shouldn't be punished because of this event that occurred. I am more than willing, Your Honor, even though I feel like I acted in good faith at every step, I am more than willing to compensate plaintiff's counsel for any time or attorney's fees or costs that they've spent or incurred in reliance on the default as provided by the court rule. I have no problem doing that, Your Honor. But as the court is aware, our case law favors the adjudication of cases on the merits. And this is not a case where we were being recalcitrant or where we were hard to find or where we were not participating. Again, we'd filed 2 answers already. And this was not a case also where the default was filed some significant period of time after the answer was due. It was just a few days. So, Your Honor, again, I think that equity in this case favors that this case be adjudicated on the merits with good cause. With regard to the affidavit of facts, Your Honor, for the meritorious defense, there's a few defenses in this case, Your Honor, that we feel are meritorious. Initially, Your Honor, I think it's agreed in this case by opposing counsel that the plaintiff, Mr. Moran, is a public figure. I also think he's a public official by virtue of his status as a school board member, an elected member, and therefore he's subject to the elevated standard of actual malice with regard to defamation claims. So, Your Honor, I think, number one, I don't think that the plaintiffs are able to show actual malice in this case because my client did not believe that what he was saying was untrue, and he did conduct what I would call an investigation to determine that it was true based upon what he personally heard at the dinner he attended and his conversation with the school superintendent. So your honor, actual malice is one of our primary defenses with regard to the defamation claims. The other defense, of course, would be the defense of truth, which is a defense, an absolute defense to all claims of defamation. And in this case, we've not conducted any discovery. And so we don't really know whether the claims are true or not for this record. My client's under oath testimony is that he heard the Mr. Moran himself the plaintiff, Mr. Moran himself, make these statements, and that he was advised on good authority by the school superintendent. And so if the statements are true, your honor, then that's an absolute defense to the claim of defamation. And so we just haven't had any discovery, your honor, and we haven't had a chance to suss those issues out. So I do believe that we've established meritorious defenses through the affidavits of facts. Your honor, I would also just ask the court to consider the case law, which establishes the interplay between meritorious defenses and good cause. As the court's aware, I believe, your honor, that there's good cause here for what we've discussed, given that I never received an effectual service copy of the order. However, your honor, even if the court found that good cause was modest in this case, the defenses that are present through the affidavits of facts, your honor, can stand in to buttress the good cause. And our case law says even in cases where there is no good cause found, where there are meritorious defenses, those defenses can stand in to justify the setting aside of a default. So, your honor, in this case, in summary, your honor, my office never received an order through the mail, which is what triggers my office to calendar deadlines. We were absolutely participating in this case vigorously. Ms. Jasinski and I had discussed discovery. We had participated in every court hearing so far. We filed 2 answers so far. So we were an active participant in the case, your honor. And again, your honor, Michigan has a well-established principle to favor deciding cases on the merits and adjudicating cases on the merits. And so, your honor, if there are other remedies available in this case, such as compensating the plaintiffs for any time or fees or costs that they incurred on the default, and we're more than willing to do that, your honor. But between the fact that we did not receive a service copy of the order through the mail, your honor, and between the fact of my personal constraints with my niece having a life-threatening illness, she resides with me, so I was out of the office caring for her for much more than normal, which unfortunately hindered my ability to perhaps catch what would otherwise have been something I would have caught if under these circumstances. If I was in the office as much as I normally am, maybe would have caught the fact that we hadn't received the order, something like that. But those, your honor, for those couple of reasons, your honor, in addition to the defenses that we raised in our affidavits, the issue of the issue of Mr. Moran being a public figure and public official, and the absolute defense of truth, your honor, I think we have established very thorough and appropriate defenses in this case that justify having this case heard on the merits, your honor. I would respectfully assert that it's not equitable to have my client suffer this sort of a result for something that he had no control over and was not his fault at all. So I would welcome any other sanction or appropriate action on behalf of that the court finds is appropriate. But I do feel we've established good cause. I do feel we've established a meritorious defense, more meritorious defenses, plural. And therefore, your honor, I feel that the default should be set aside. Again, if the court feels that the good cause for some reason is modest, then I would ask the court to be mindful that a meritorious defense can stand in and buttress both sides of that analysis, the good cause side as well, given that the state does have this favorable view of adjudicating claims on the merits. So I would respectfully, your honor, ask that we be allowed to continue in the case and that the default in this case be set aside with any conditions that the court deems appropriate. Thank you, your honor.
Okay, thank you, Mr. Flory. Mr. Jasinski, your response.
First, let's address, your honor, if I may, the 2 answers that Mr. Flory is referring to that he filed in this case on behalf of his clients. So the court may remember the first answer that he filed was subject to a motion to strike. And that motion to strike was because that answer did not comply with the court rules, contained something like 85 affirmative defenses. And the court very closely examined those affirmative defenses, called Mr. Flory on some of those affirmative defenses, for example, one being the existence of an arbitration agreement, struck the answer and directed him to file a new answer, a new affirmative defenses. That new answer and affirmative defenses were filed on or around March 4th. They're in the file, and we had significant problems with that as well, Your Honor. It almost ignored the court's order completely. Nevertheless, while we were in bankruptcy court with Mr. Bishop's Chapter 7, we were able to obtain relief from the stay to get Mr. Bishop's claims or against Mr. Bishop back in this court. And then starting on March 4th, began a series of calls and emails to Mr. Flory's office to discuss the filing of a first amended complaint. Those emails and other correspondences are reflected in Exhibit I to a motion for leave to file an amended complaint that was filed in this court on May 2. And it was a result of Mr. Flory's complete non-responsiveness to those emails that it was necessary to file a motion for leave to amend, which added citation to a criminal statute, another criminal statute that he essentially accused Mr. Moran and Moran Ironworks of violating, federal criminal immigration laws that constitute felonies, and also asked in the request for relief that Mr. Bishop and defendants be required to publish a very specific type of apology in the event that the court found in favor of plaintiffs. And why is that? Because Mr. Bishop essentially retracted his retraction after the complaint was filed. So as a result of non-responsiveness by Mr. Flory, we have a hearing set. We file our motion for leave to amend on May 2. We have it scheduled at the time of a May 12 scheduling conference. And at that time, shortly before the hearing, Mr. Flory said, well, I'll stipulate to the relief. I was not willing to allow that order to sit in his office because we had provided him with a stipulated order before for a nanosecond longer because it appeared that he was slow walking the case. So while we were at the hearing on May 12, the first matter that the court addressed was the motion for leave to amend. I had an order, and if the court were to look at its docket, and I pulled up the docket entry concerning that, it said plaintiff attorney had order ready, judge signed, order granted. Motion for leave to file first amended complaint and signed order, plus the scheduling conference was held at that time. And among other things that defendants were required to do were to file their initial disclosures within 14 days, which they haven't done. So in any event, Mr. Flory is at the hearing on May 12th.
So that's going to his actual notice.
His actual notice, and what he's not alleging, Your Honor, he's saying, I cannot find where I ever received a hard copy of this order granting leave to amend. What did the order granting leave to amend say? The complaint, the amended complaint that is attached to the motion that he had received, that had been filed, that there is leave to file that amended complaint that was attached to the motion as Exhibit B. So he knows the order has been signed by this court on May 12th. The pleading itself is attached. And what Mr. Flory is not saying is that he didn't receive the amended complaint that had been filed. He's not saying that. He's saying, I didn't get a copy of the order, but he's not disputing that he did not receive the amended complaint, which was emailed to him as well as sent via ordinary mail as the certificate of service reflects in the court file. So that's what we have in terms of what they did or did not receive, they're not claiming we didn't send it. They're just saying they didn't receive it. But we know that he's not claiming he didn't receive the first amended complaint. Now, normally, Your Honor, I would not throw a secretary under a bus because I worked as a secretary through law school, and I think that's just bad form. But Mr. Flory, in connection with the motion for summary disposition that we heard back in February, when it was pointed out to him that Mr. Bishop's affidavit that was submitted completely unsigned, and it was pointed out in a reply brief at the hearing, Mr. Flory stated, Your Honor, we did receive that back from my client, meaning an affidavit, Again, it's my experience. It's pretty common practice to submit an unsigned for those purposes and then supplement it prior to the hearing. Obviously, we are in the hearing now. So I asked my legal assistant to forward that by email. Apparently that has not been done. So he threw his assistant under the bus for not timely filing an affidavit, presume that it exists. And then today we're hearing that, well, we just can't find the order granting the motion for leave to file the amended complaint, although no dispute that they have the amended complaint that was attached. So I would argue, Your Honor, that that is not good cause. The other thing to point out in terms of the requirements under the court rule to set aside any kind of default is that it is necessary to have a statement of fact showing a meritorious defense verified in the manner prescribed by MCR 1.109 D3 is filed. They haven't done that. They haven't done it. Exhibit, the court will excuse me for a moment so I can grab the document. The exhibits that are attached is the affidavits for Mr. and Mrs. Bishop are signed. They're not notarized. The court rules are very, very specific.
I have one that is notarized. It says notarized by Kristen Todd.
Does it say subscribed and sworn? Does she fill in the date? She does
Well, she
not.
has a stamp. Actually, oh, okay, but it's not.
It's not signed.
Okay.
It's incomplete. Both of them the same way.
It's an incomplete notary, but okay.
It's not verified in the manner required by the court rule. And neither is, the court rule does provide for another option that doesn't require a notary jurat, and that is that it is, I declare under the penalties of perjury that this affidavit has been examined by me and that its contents are true to the best of my information, knowledge, and belief. That's not in their declaration either. So you have the same kind of situation, frankly, Your Honor, that we had in the motion for summary disposition. There's a signature there, but Ms. Todd, who is Mr. Flory's assistant, who knows how to notarize a document because she notarized Mr. Flory's affidavit and he notarized hers and completed it properly, showing, the subscription and sworn language that you see to make an affidavit effective. So they have not submitted an affidavit of meritorious defense, Your Honor, that's compliant with the court rules by any stretch of the imagination. The other thing that I would point out, Your Honor, and I am not for a moment going to get into a battle regarding the seriousness of the family illness that Mr. Flory has described, but I would point out to this court that it did not prevent him from becoming quickly involved in the bankruptcy matter in an effort to prevent Mrs. Bishop from being held in contempt for failure to appear for her Rule 2004 exam.
Well, I agree with you that normally courts and opposing counsel are very forgiving when those family issues come up with other attorneys. Here, there wasn't really much of a time. There wasn't much specificity about the time frame in Mr. Flory's affidavits. And I understood his argument to be, it prevented me from being in the office as often as I otherwise would have been, which seems to leave an awful lot of wiggle room. So he was still working throughout.
Well, particularly because he managed to get an affidavit from Mrs. Bishop's treating physician in an effort to convince bankruptcy judge James Boyd that Mrs. Bishop should not be held in contempt for failing to comply with her Rule 2004 exam order that was served on her personally. And that affidavit appears to have been sent to Mr. Flory's office on May 30. And I have a copy I would like to look at it showing the transmittal, and that Mr. Flory then in turn provided it to bankruptcy counsel for Mr. Bishop, so that he had time to do other things in connection with this case. and did those things. But it comes back to, Your Honor, the fact that they haven't shown good cause, because the critical document here, it's not so much the order that he knew was signed because he sat in the hearing, but he's not disputing he didn't get the amended complaint. And what they have shown or provided to this court in terms of the requirement to show meritorious defense does not comply with the court rules on its face. So they haven't sustained their burden of proof. The entry of default should not be set aside. This matter should proceed to a case on damages. In the court, we're asking for the court to sign an order entering a default judgment on the issue of liability against defendants. I would point out that also, Your Honor, one of the things that Mr. Flory has asked for is an additional 7 days to file his answer. If we're going to get the same answer that they filed the first time, and frankly, Your Honor, the second time, which the court can look at and will have a sense of deja vu, have I seen this before? Yes, you have, because they still, despite one of the topics that we raised back in February, they still can't bring themselves to admit what Mr. Bishop said on the air, the words that came out of his own mouth. They still continue to say, well, we lack information or knowledge sufficient to form a belief as to what he said. So we're going to continue to play those little reindeer games. If he's given another 7 days to file an answer, that's going to be no different than what he's filed to date. And he shouldn't be allowed that privilege because of the failure to comply with the court rules.
So do I understand your argument a little bit to be, I mean, you'd acknowledge, wouldn't you, that it'd be at least unusual for a default to remain for failing to file an answer to an amended complaint when the defendant has already been in the case and litigating the case. But it seems to me you're trying to highlight the manner in which the defendant's participation in the case was not perhaps fully in good faith anyway.
That is exactly what we're arguing. And the arguing that, oh, we've participated and, you know, we're out there and yeah, we filed an answer. Yeah, they filed deficient answers in an effort to get an amendment to a complaint, didn't respond for a month and a half, necessitating the filing of a motion. And then only at the hearing, he said, oh, well, fine, you know, I don't have any objection to that. But he wanted to, I have the stipulated order that Ms. Jasinski sent to me. I will sign and get that back. No, Your Honor. And if you were to look at the transcript again, because I was before the court and had the order there, I did not want that to disappear into another black hole. What they've been doing is slow walking this case. And so while it might be unusual, given the posture of the case, when you look at what's occurred here, the relief in allowing the default to stand is fully supported.
All right, thank you.
Thank you, Your Honor.
Mr. Flory, rebuttal argument, sir?
Thank you, Your Honor. Your Honor, I'm a little confused. I think a lot of what Ms. Jasinski referred to is outside the purview of the motion in here. Your Honor, Ms. Jasinski never took action after receiving our amended complaint to say that it was deficient. There was no motion filed. She never told me that she was dissatisfied with it. So if the court, you know, I'm a bit flummoxed here because I was never made aware of that. We complied with the court's order. We submitted a timely amended complaint to the original complaint, timely amended answer to the original complaint. And Ms. Jasinski never contacted me to tell me she had a further problem with it. She never filed a motion. And so this is the first I'm hearing of that. It's not uncommon for an opposing party or counsel to dislike the answers. I'm sure Ms. Jasinski does wish that we would just admit everything. I'm sure she does wish that we would admit this or admit that and make it easier for her client. But my client has the right to answer the complaint honestly, Your Honor, and in a manner that that is consistent with his best interest and is overall consistent with the truth, which is obviously what's been done. So,
what about the seeming persistence then to fail to admit just simply a bare allegation about these are the words that were broadcast?
Your Honor, with regard to that, this is what I can tell the court, and I'm bound by what my client tells me, Your Honor, but my client has told me that he simply does not remember with specificity. The recordings have been taken off. They're gone. They've been moved from access, Your Honor. So my client couldn't even go back and review those if he wanted to. And so, Your Honor, when my client thinks about that, he tells me he doesn't remember if that's what he said or not. And Your Honor, I think with respect, that's what we'd get into during discovery in this case. We would get into what my client knows. And again, that's going to come up during his deposition. So, Your Honor, when my client's answering an allegation and a complaint, and the allegation is, you said these words, and it's a quote, verbatim quote, my client's telling me, I don't know for sure if that's what I said or not. So, Your Honor, that's just the truth of the matter. And we're not slow walking this case, okay? I apologize, Your Honor. We're not slow walking this case. We participated at every single stage. So, again, I've advised that I've been out of the office because my 13-year-old niece was about to die, and I was caring for her. So that affected my ability to get back with counsel as quickly as I would have ordinarily liked. Ms. Jasinski's not the only opposing counsel that I have on a case where I didn't get back to her as timely as I otherwise would have liked. But at the end of the day, Your Honor, I stipulated to that relief. I provided Ms. Jasinski with an extension to answer our counterclaim when it was originally filed. I have been courteous in this case, Your Honor, as I always am.
Can I ask you, with regard to the actual notice question, what about the plaintiff's argument that you knew because you were at the pretrial conference that I was on the record signing the order that you should calendar it right there? The order is being entered. Why don't you just calendar that to file an answer then? So you don't dispute that you have actual notice from that moment in time, right?
Your Honor, I was at the hearing and I saw the court entering the order. I absolutely should have calendared it then. Again, in my view, and Your Honor, I'm saying that because I should always do best practice, right? I should always do best practice. I should always take a belt and suspenders approach to everything. But Your Honor, I'm a human being. And so in my mind, when I've got 100 other cases that I'm tending to, I know that I have that order coming in, and that's what's going to get to my secretary, and she will then get the matter appropriately on my calendar. And Your Honor, again, with regard to the complaint, to my knowledge that those were sent in one package, the amended complaint with the order effectuated by the court. So that's what I didn't receive, Your Honor. So should I have, would it have been best practice to have a calendar that day? Absolutely. It would have been, it'd be best practice to calendar it at every opportunity. But at the end of the day, I have in my mind, because I have 100 other cases I'm working on, I have a system where when my assistant gets the documents through postal mail, that's when I can ensure that things will get on my calendar. And Your Honor, I arrived at that system because frankly, I had problems with things through email. I would sometimes forget to forward emails. Some emails would get lost in my junk folder. I wouldn't see them. And so that's when I added that to my signature block in email to say I can't do email service only. I have to have that hard copy because that's how I make sure it gets on my calendar. And so, Your Honor, and again, that's what's required by the court rules as well. And I don't want to be pedantic and say, well, I can't work with you. I can't take email service. I have to have paper service. But that's what I found is necessary for me in order to ensure that it's appropriately documented and that I comply with deadlines. So, Your Honor, again, in this case, I was entitled to an order sent via mail. I don't know whether
but it was sent. It was sent. So service, and so you'd agree service is complete upon mailing, not upon receipt.
Your Honor,
so you're not contesting service was made by mail. You're saying, well, I never received it. And even though that doesn't defeat the service, that establishes the good cause to set it aside. That's a little different than saying you were never served it, right? No. There's a certificate of service.
Yes, Your Honor. Your Honor, what I'm saying is this. I have no idea whether they served it. They're saying they did, and I don't have any reason to not believe them. So
okay, well, then they did.
Ms. Jasinski is a very competent lawyer. I don't think they would lie to the court, just like I would not lie to the court. So I'm taking them for their words, saying they served it, and that's what I'm taking it on, Your Honor. But again, Your Honor, I did not receive anything, and so that's not my fault. That's just not my fault. I may be guilty of, I should have done this best practice or that best practice, But I've never had this happen before. I've never had it happen where I just did not arrive. And so, Your Honor, that's the system that I've arrived at personally to ensure that deadlines are appropriately documented and on my calendar. So in this case, Your Honor, again, I have, of course, would not say that someone else is being untruthful. I have no reason to say that at all. What I do have a reason to say is that I never received the order or anything enclosed with the order, which I believe was the amended complaint. And so, Your Honor, my client should not be punished for that. Not in a case that he's been contesting it and litigating it, and not where there's other remedies available. We will happily compensate plaintiff and plaintiff's counsel for costs and fees incurred in reliance on the default, or we'll happily do any other action the court would like. I put 7 days in the motion, Your Honor, simply because I thought that was customary, and that's what I've seen in my career in private practice. If the court would like an answer filed by tomorrow, we'll get it done. There's no problem there. We will comply with whatever condition the court would like. But at the end of the day, Your Honor, we did not receive a service copy. That is what, in my practice, triggers the deadlines to be documented. And Your Honor, I have been out of the office much more than I otherwise normally would have been. Normally, Your Honor, I'd work 6 to 7 days a week, 12 hours a day. Now I'm probably working 4 days a week for 6-8 hours a day. And so I'm not having as much touch with the files as I otherwise would be, because my niece was about to die. And she's been in recovery and recovering from extremely serious throat infection. And so, Your Honor, moreover, with regard to the affidavits of meritorious defense, I don't have them right in front of me, Your Honor. I have my brief. I'm not following.
I'm not persuaded by Ms. Jasinski's argument on that there was the notary jurat. It was defective because your notary didn't put in the date that it was subscribed to. I'm not going to hang my ruling on that hyper technicality. She, I think, is technically correct, but I'm not basing it on that.
Well, thank you, Your Honor. And I apologize. I thought the date was in there. Again, I don't have it in front of me. Well, I apologize, Your Honor. So again, Your Honor, there's one other.
I'd let you go a long time. If you start now, an hour into the hearing, and say again, and if you're going to tell me something I've heard 3 times, consider whether that's super helpful right now.
I apologize, Your Honor. I'll give you one more piece of new information, then I'll shut up, Your Honor. I apologize. Your Honor, the only piece of new information I wanted to add is that there was one more defense that is discussed. I mentioned the 2 public actual malice with a public figure and public official. Number 2 is truth. Number 3 is the retraction, Your Honor. And again, Ms. Jasinski is unsatisfied with the retraction. That's not surprising, but my client did commit the retraction. He read it verbatim from the letter he received. And so that's another meritorious defense, Your Honor. So we've established at least three meritorious defenses, Your Honor. So, Your Honor, in summary, we have been actively participating in this case. It would be completely inequitable, I respectfully submit, to have my client punished for something he had no control over. We did not receive a service copy. We, and again, with the personal matter with my niece nearly dying and still in a precarious health situation, Your Honor, I think that does establish good cause. We have established at least 3 meritorious defenses through our affidavits, Your Honor, so I believe that is satisfied as well. And we'd be happy to comply with any condition the court imposes, such as any kind of monetary sanction, compensating plaintiffs, or any kind of deadline. Again, we can have the complaint filed or the imminent answer filed by tomorrow. So, Your Honor, again, I think we've met our burden here. The state favors setting aside of defaults and having matters determined on the merits. I'm respectfully asking the court to allow us to do that and to set aside the default here, Your Honor. Thank you very much. I appreciate the court's indulgence.
Thank you. The plaintiff filed an amended complaint with leave of the court, and certificate of service in the file dated May 13th, 2025, signed by Ms. LaHaye from Plaintiff's Counsel's Office, shows that that order and that the order allowing the amended complaint and the amended complaint were served by mail. There was also an email sent, but service by mail was effectuated. The court rules make it clear that service is effective upon mailing, not upon receipt. So the order and the complaint were properly filed and properly served. The defendants did not file an answer, and then a default was properly entered. There's nothing improper about any of those procedural steps that were taken. The defendants have moved to set aside that default nonetheless because they have good cause for failing to file the answer and meritorious defenses. They say that the meritorious defenses are very strong and that means that minimal good cause would be required to be shown. The case law does support that as a general proposition. I don't think it gets to the point where no good cause need be shown at all. There is a requirement for there to be some good cause for failing to file it. The asserted good cause is that although it was served, I mean, there's a certificate of service that Mr. Flory says he doesn't have any reason to think is fraudulent. So service was effectuated. He's saying, but I never received that mailing, and that would be my good cause for failing to respond to it. It would be a difficult spot for the court to try to decide, well, what do I do in that circumstance where one party did mail it and the other says they didn't receive it? It might seem unfair to then allow a default to stand if it was not received. But on the other hand, we can't establish a precedent that everybody who fails to meet some deadline can just say, well, I never got it, because the court rules say that, it's service by mail when you mail it. So to just willy-nilly set aside any deadlines when somebody says we never got it in the mail, I'm not sure whether that's the right answer either, but that's a difficult question. That's not the question I really have to answer today, because it is relevant to the good cause determination what the status of defense counsel's notice of the pleading was and the order was. And here he did have actual notice of it in two respects. One, it was sent by email, and he doesn't dispute that he received that email. And secondly, as pointed out by plaintiff's counsel, the order was signed on the record at a hearing where Mr. Flory was present by Zoom. So, sir, there was proper service. If the good cause is I never got it, but I had 2 times over actual notice of it, that doesn't strike me as honestly any good cause at all. The court is very sensitive to family medical issues. Of course, that sometimes requires excusing certain procedural defaults. But in this case, I think it just doesn't justify that. There's no specificity about what dates he was gone. There's not even a claim that because of some family medical emergency, defense counsel was unable to work. He just says, instead of working, 7 days a week, I'm working 4 days a week at 6 to 8 hours, which is still, about full time. So he's still in the office working his cases. So there's just no clear basis to say that that's good cause for excusing procedural defaults. The defense counsel says, well, don't punish my client for this. I mean, that's true in any procedural default in any case. And that's why the case law has been very clear for a long time that, litigants are, it's imputed to litigants the actions and inactions of their attorneys. There's no real other way to deal with litigation in an orderly fashion. Courts do disfavor defaults and favor setting them aside, but there has to be some good cause shown. And I especially would disfavor a default where somebody was in the case already and participating. I think it is relevant that the plaintiffs point out that defendants' litigation in the case has not been without its own problems and procedural deficiencies.
Your Honor.
So in this case, Well, Mr. Flory, I mean, I let you argue and argue for a long time, and now I'm announcing a ruling. I'm not sure in all the courts I practiced in, that means that the arguments are finished. All right, and I thought we had this problem last time where you tried to argue with me during a ruling. It's not something I look upon favorably, sir.
Sorry,
All right, so now I've lost my train of thought because I've been interrupted by counsel during a ruling on the record. All right, so in this case, there's no good cause because there was proper service and the lack of notice is unpersuaded when there was in fact actual notice by two methods. So therefore, the motion to set aside the default is denied. And I suppose because you're not asking for any relief in your motion for default judgment, just an entry of judgment on the issue of liability, that pretty much takes care of that motion. Anything further you want to say in support of your motion?
No, Your Honor, the only thing that we would be asking for in addition to a judgment of liability is just for the court to settle, to set a date for a trial on damages.
Well, you still are, they would still be allowed, would they still be allowed to proceed with discovery on the damages? I mean, I think that'd be fair, right? I mean,
sure.
Yeah. So we do have discovery set open and we have a settlement conference for October 8th. Should I just leave that on? And then at that date, if it's not resolved, we'll set trial dates.
So we can proceed with discovery on damages.
Yes.
Your Honor, may I?
Mr. Flory, what's your response to the motion for entry of a judgment as to liability only?
Thank you, Your Honor. And Your Honor, I apologize for interrupting the court. That was not right. I'm sorry. Your Honor, I think we are entitled to discovery on that issue, Your Honor. I think the court has already set a schedule. So, Your Honor, if it pleases the court, we can continue with that schedule because I think we are entitled to that discovery. Your Honor, I do have one request of the court. And I can file this by way of motion if the court would like, but I would like a stay of proceedings, Your Honor, to allow us to file an appeal on this issue of the default. I think that, Your Honor, it would obviously be a duplication of efforts if we engaged in discovery not on liability and then somehow the Court of Appeals found in our favor and had us redo discovery on that. And so I think, Your Honor, for time's sake, it makes sense to have that issue addressed at this time. And so I would respectfully ask for a stay of proceedings to allow us to file an interlocutory appeal on that issue before we engage substantive efforts that may have to be duplicated at a later time.
Ms. Jasinski, do you waive notice of that or would you require a motion?
Well, I'm not going to waive notice on it. If he wants to file a motion, he can, but I can tell you right now, we're going to oppose it.
Okay. All right. So you'll have to file a motion for a stay. So I'm going to grant the plaintiff's motion for entry of a judgment as to liability only and restricting the scope of discovery to damages. And we'll leave the discovery period open with that restriction. And the currently scheduled settlement conference for October 8th at 10:30 will remain docketed. At that point, we'll schedule a trial if necessary. And Mr. Flory, you can file a motion for stay and contact the assignment clerk for hearing dates. And I'll consider that motion in due course. And you guys can take whatever remedies you want, regardless of my ruling on that. Okay.
Thank you, Your Honor. Your Honor, if I may, one other point, just housekeeping that I'd like to raise. The court may recall that at our last status conference, I believe I advised the court and Ms. Jasinski that I would be traveling to Arizona for my wife's brother's wedding in the September-October timeframe. We are going to be in Arizona, Your Honor, on October 8th. And so if you'd like, we can, if the court's amenable to moving that until we can get back from Arizona, I'd appreciate it. And I'm sure Ms. Jasinski and I can work cooperatively with your assignment clerk to arrive at a new date if that were acceptable to the court.
I think given the way that, well, I guess, Mr. Jasinski, do you consent to that right now? Or I was going to say, given the extent of loggerheads that counsel seems to have been on in this case, I guess I'd require either a stipulation or a motion so that we can deal with it that way. So check with Mr. Jasinski off the record and see if you want to submit a stipulation for a scheduling order adjustment. I would certainly sign that. If she's not agreeable to that, you can file a motion either for an adjournment or an appearance by Zoom if Mr. Jasinski consents to that. So I'll let you guys talk and sort that out.
Thank you, Your Honor.
You guys have to be talking anyway about the stay issues, and you guys will be talking in any event. You can talk about that and notice up something if you need the court's assistance.
Thank you, Your Honor. So, Your Honor, just to clarify the court's ruling, then the case will essentially proceed as previously identified, just with a circumscribed period of discovery as to damages.
Yeah, not a circumscribed period, but the scope of the discovery. Yeah, the scope of the discovery will be limited to damages.
Thank you very much, Your Honor. Appreciate your time this morning.
Okay. All right. Thank you both very much. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor. We are present in the state of Ohio versus Dennis Welp in case number 25 CR 206. The defendant is in court represented by counsel. We were last here on May 14th where the defendant pled guilty to count 5 and count 6, both being sexual battery felonies of the 3rd degree. At that time, the court referred the defendant for a pre-sentence report and victim impact statement.